Imagine this: you're at home one evening, dealing with a heated argument with your spouse, nothing violent, just voices raised after a long day. A neighbor hears the noise, misinterprets it, and calls the cops. Next thing you know, officers are bursting through your door without knocking, without a warrant, claiming they thought someone was in danger. They rummage around, spot something unrelated, like an unregistered firearm or even prescription meds not in the right bottle, and suddenly you're facing charges. This isn't some dystopian fantasy, this is the reality backed by the Supreme Court's latest ruling in Case v. Montana. Let me break it down for you, step by step, so you understand exactly how this erodes your rights as a homeowner or parent just trying to live your life. The core of this is the so-called emergency aid exception, a judge-made rule that lets police enter your home without a warrant if they have what the court calls an objectively reasonable basis to believe someone inside is seriously injured or about to be. This doctrine didn't come from Congress or some statute, it originated from judicial interpretations, starting with cases like Brigham City v. Stewart back in 2006, and now solidified in the 2026 decision in Case v. Montana. The court justifies it by saying safety trumps privacy, that in exigent circumstances, waiting for a judge to sign off on a warrant could cost lives. They balance the government's need for quick action against your Fourth Amendment rights, and guess what? Efficiency wins every time. But here's where it stretches way beyond the Constitution's text. The Fourth Amendment demands probable cause, specific, sworn facts, for any search warrant, especially in your home, which the founders saw as sacred. This ruling dials that back to mere reasonableness, letting cops decide on the spot based on vague reports or hunches. In the Montana case, it was a neighbor's call about loud noises, officers claimed it sounded like a fight, entered without consent, and the court said that's fine. Now apply this to your daily routine: you're a parent disciplining a loud kid, or maybe someone's having a medical episode that sounds alarming from outside. Cops show up, invoke this exception, and bam, they're inside, potentially escalating a private matter into arrests, child services calls, or worse. Think about the real-world fallout. In recent months, we've seen spikes in these warrantless entries tied to wellness checks or domestic calls, especially in communities already over-policed. Data from 2025 to 2026 shows more home raids under immigration pretexts using similar administrative standards, where IC claims reasonableness to barge in. For you, as an ordinary renter or worker, this means your front door isn't the barrier it used to be. One misinterpreted noise, one nosy neighbor, and your privacy evaporates. And if this precedent keeps expanding? Expect more procedural traps, civil forfeitures from items found during these 8 entries, or regulatory penalties if they spot code violations. It's a gateway to broader surveillance in everyday life, chipping away at what little protection we have left. This isn't just legal jargon, it's a direct threat to how you live. If we let courts keep rewriting the Constitution like this, your home becomes just another stop on a cop's patrol route. And mark my words, this is only one piece. Next time, we'll dive into how geofence warrants are turning your phone into a tracking device for the state.